All right, this is Judge Marilyn Haan. But I can't hear you. All right, am I being heard through? All right, this is a check to see that I'm heard.
I can hear you, Judge.
Okay. All right, thank you. Good morning. This is the Cowlitz County Family Law Attorney Docket A, and we have one matter that is going to be heard first on. I recused yesterday off of this matter, and Commissioner Carmi is on here to address any matters here today. So I defer over to Commissioner Carmi at this time.
Thank you, Judge Haan. Good morning. I'm over at the juvenile department and my screen isn't showing me who's online. Do I have Ms. McLean?
Yes.
Okay. And then do I have William Dombrowski?
Yes.
Okay. And you can hear me okay, sir?
Yes, ma'am.
Okay. So I have us on, and I think this is a case due to recusals that I'll probably be pre-assigned to. We're on for pre-trial today. I guess I'll first turn to Ms. McLean to see if there's any issues we need to deal with, and then we can talk about scheduling.
No, Mr. Dombrowski and I have exchanged updated wage information, and I anticipate that we will have court aids exchanged by Monday.
Okay. Mr. Dombrowski, go ahead, sir.
Yes. Yeah, we've exchanged all pertinent information, and I'll have all my pre-trial stuff in by Friday of this week. The only thing that I would say is that there's already been 3 judges recused from this case.
Correct.
And there's not that many judges in Cowlitz County. So how do I feel that I'm going to get a fair shake and a fair trial when she works directly with the commissioners and the judges?
Yeah, so sir, that's why I'm a court commissioner. I'm actually hired by the judicial officers, not by the county board. So that's why I'll be pre-assigned to this case to address that specific concern.
Okay, I understand that, but Mr. Basher, Judge Basher, committed a pretty volatile act when he heard a case on a recusal, and then he recused himself the same day, knowing that he was the one that had ex parte communication.
Okay, so what I'm going to do today, if it pertains to this specific case and you want to file any information, motions, briefing, feel free to do so. But what I'm going to do today, because I haven't been involved in this case, I do believe that I can be fair and impartial. I have no knowledge of either the petitioner or the respondent. So what I see is that you all are set for a half-day trial the week of February 12th. Do we anticipate that we're going to keep that week?
Yes. Yes.
Yes, I would like to keep. Sorry.
That's okay. The only potential issue is that my client will be out of the state through the 15th, so we would need to accommodate her by Zoom if it's going to be held the 12th through the 15th. If we're heard on the 16th, which is Friday, then she anticipates being back then.
Okay. And I did just speak with our court administration, and the proposal that will work for my schedule is the 16th at 1 o'clock, that afternoon half day. Will that work for both parties?
Yes.
And Mr. Dombrowski, will that work for you?
Yes, that'll work for me. But I have one question. Everything that I've been told is you can't come to the courtroom. It's all via Zoom. So I don't know what her problem is being out of state. Has to do with it. Because it's all via Zoom.
Not correct. And that's why I think Ms. McLean said she was confirming that it would need to be by Zoom. If a party requests in-person appearance, we can accommodate that typically. So are you wanting to be in person for the trial?
I would prefer to.
Okay. Let me make a note of it. Oh, go ahead.
I mean, I'll go either way. At the clerk's office, they said, no, you can either do it via Zoom or you can sit in the hall and use one of the computers at the hall, at the court hall. So
Your Honor, I have no preference. I mean, I have no problem coming into the courtroom, and just assuming that my client doesn't have any difficulties with flight. She's supposed to fly
Yeah.
back from her work conference on the 15th. And so we fully expect that she should be able to be present on the 16th if that's your preference. If you prefer to hear this by Zoom, we don't have any problem with that.
Okay. It sounds like, and Mr. Dombrowski, I noticed you're not using a camera today. Do you have some concerns about accessing technology during a trial for presentation of your evidence? Is that why you're asking to be in person?
well, I don't have a computer. I don't own a computer.
Okay.
Everything I do is I either have to do it at work or I do it on my phone. And so it makes it very, it's a disadvantage.
Okay. Let me do this then. Let me just make sure we will have a courtroom available to us. And then I can send an email confirmation through my judicial assistant to both Ms. McLean and to you, Mr. Dombrowski, to confirm that we could accommodate in person. And I believe that we can.
Okay, I'd appreciate that, Your Honor.
Okay. Do we have a good email on file for you? I'm just looking
Yes.
at the document. Yep, we do. The Hotmail account, is that still the best one?
Yeah, yeah. Is it BKSK?
Yep, that one.
Okay, all right. Because I didn't get nothing
Okay.
from the clerk's office. I got something from Miss McLean about today and Judge Haan.
Okay.
So she's been very
Okay.
forthcoming.
Absolutely. I'll go ahead and confirm availability of a courtroom. I think you all still have readiness set for February 6th at 11:30. That will be by Zoom only, so go ahead and keep that appointment. And then we'll confirm on that date that we are moving forward for trial February 16 at 1 o'clock.
Okay.
Thank you very much.
So we got February 6th. Give me just
At 11:30 a.m. Yep.
Feb 6th, 11:30, and then February 16th at 1 p.m.
Correct.
And are those on which docket will they be on?
So the February 6th docket will be trial readiness.
Okay.
And that will only be on Zoom.
Okay. And
then at that time, I'll confirm with you courtroom availability for February 16, okay?
Okay, perfect. Thank you, ma'am.
Thank you.
You are welcome. Anything else on this matter?
No, thank you.
All right. Thank you both.
All right. Have a nice day.
You too. All right. Judge Haan, I will go ahead and log out.
Hearing for the petitioner,
Thank
Jody
you,
Peterson, who is now known as Jody Wattier.
And good morning, Your Honor. Michael McGrath for Steve Peterson.
Okay. All right, this matter comes on for a request for a guardian ad litem. Go ahead.
Your Honor, excuse me, Your Honor. Unless something has come up in the last couple of days that I'm not aware of, Mr. McGrath and I have been discussing this, and both parties are agreed that GAL needs to look into a situation with this family, not just to investigate allegations against one parent or the other, but to look into the whole situation so that we have some objective information to hopefully resolve what's been going on with one of their teenage children. Our office provided a copy for signature yesterday, which I also forwarded to Mr. McGrath. So unless Mr. McGrath disagrees with any of the language in that proposed order, we just need to select a guardian ad litem, set a review schedule. And I will also just point out that, as you can see, the court file is quite large. And given the potential amount of information that a guardian ad litem might have to review, Mr. McGrath and I have discussed setting a limit of $2,000 rather than $1,500 before a guardian ad litem would have to come back to the court for approval for additional time and billing. We are also asking the court to set a date for an interim review rather than 4 weeks out. I would think a minimum of 6. Mr. McGrath apparently agrees that that would be sufficient.
Yes.
So let me go back to the fees. Are you talking about county pay, private pay? What are you talking about there?
Private pay, and we are proposing that parties share it 50-50.
All right, Mr. McGrath.
No objection to anything counsel said.
Okay. So who do we have as the next 3?
Karen Moritz, Twyla Corey, and Ann Height.
I'm sorry, I didn't catch the first name.
Karen Lawrence, Twyla Corey, and who did you say, Ann? And Height. Ms. Dow?
Your Honor, I don't have any major objections to any of the three. I would say, maybe not Ms. Corey.
Mr. McGrath, do you strike any of them?
Nope.
Okay.
Fine.
All right, so the next one would be Ms. Lawrence. And sounds like you have a order in process getting filled out. So if you want to go ahead and get me that order to sign, fill in the dates for the reviews, and then the financial part of it as well. Go ahead and do that and sign off on that and get it to me for signature.
I can take care of that today, Your Honor. Thank you.
Okay.
Thank you, Judge. Thank you, counsel.
Thank you.
That matter's ready. We're on for review of the guardian ad litem report. Guardian ad litem report is obviously not in the file. There's a lot of moving pieces. The court might see that a motion to modify temporary orders and a contempt has been filed. I think that's on for 2 weeks from now. So there's a lot of moving pieces. Guardian ad litem can speak to how much time she thinks she needs. Realistically, again, a lot going on with these kids. And there was a lot going on with the family. I think 60 more days is honestly reasonable.
So do I have Ryan Yanis here?
Yes, Your Honor.
Okay. So would you agree with what Ms. Baldwin has indicated?
I want to give Ms. Turnbull as much time as she feels necessary. So if 60 days is what she feels is appropriate, then that's what I'm wanting her to have. I feel she'll get to the bottom of everything and ultimately have the best interest in mind for the kids.
Ms. Turnbull?
I think 60 days is reasonable. Mr. Yanez and I have just made a final payment agreement, so that will be, hopefully he will be able to, follow through with that, which will be helpful as well. And I do have some, pretty serious concerns about the children as well.
All right, so anything else, Ms. Baldwin?
Just let's set a review. So I'm thinking, 60 more days would put us about this time in March. So maybe the end of March, March 26th.
Okay.
I'm going to be out of town that week.
How about, let's see, April 2nd?
I'm out April 2nd, but I can do April 9th.
I can do April 9th.
Mr. Yanis, does that work for you?
Yes, ma'am.
Okay.
That's on Thursday.
April 9th is a Tuesday, 2024. We'll go ahead and set it to April 9, 2024 at 9 a.m. For a final review.
Very good. Thank you.
All right.
Thank you.
Maine Pittman.
Amanda Holder here, Your Honor, for Mr. Pittman.
Scott Roberts for Ms. Pittman. It's present on Zoom as well.
So just for the record, I did make contact with counsel yesterday to try to get some clarification of what we were supposed to be doing here today. And I had looked at the record and I had trying to figure out what was and what wasn't supposed to be happening. When looking back at the minutes from when Judge Evans had made a ruling on this matter, it refers to the next review date, and that was originally set on January 16th and then reset to January 23rd at 9 a.m. But what I also saw is that there had been a motion for temporary orders, and it didn't seem like those as a whole had been addressed. And maybe I missed the day of when they were addressed. That was the other thing that I was seeing. So that's what I'm looking at, just so you know what I've seen in trying to reconstruct the record on what's going on. So I know Ms. Holder was wanting to go forward on everything. And Mr. Roberts had, from what he said, understood this to just be a review. So council, go ahead. As far as what we do today, that's the only issue I want to hear about at the moment.
I'll let Mr. Roberts go first, as he's the moving party in this case.
Well, there was a motion filed by Mr. Pittman, so I'm not
Okay.
in agreement that I'm the moving party.
Okay. In that case, I'll go. So my understanding, Your Honor, upon reading the minutes, is this was a reset of the matter, and it's not a review hearing, although we do need to hear from the GAL, in this case, Twyla Corey, as she's in the process of doing her GAL report, and I believe she is here today and could potentially give us an interim review for how things are proceeding so far. But as far as the temporary order that was asked for, we put in our motion, we did our pleadings. There was no kind of responsive document that was filed for that. So there has been a lot that has happened in this case since I believe our motion was put forward on November 30th. So I'm not sure what to do here, as I think the court can look at the pleadings before it and what has already been filed, in addition to an interim oral report from the GAL. But beyond that, the only thing that is currently in place is kind of an interim temporary family law order, but nothing has been looked at for the divorce proceedings or anything like that. It is just strictly what is being done with visitation.
Your Honor, I might have some information that hopefully can clear things up, and maybe we can all get on the same page. There's a parenting plan issue, and my position is that Ms. Corey will provide an update, and that we can deal with it under that umbrella. There were additional requests from in Mr. Pittman's motion specifically with respect to the vehicles. My client is using the Volkswagen, he's using the Expedition. I think we have an agreement on that issue. And protecting property, I think we have an agreement on that. The household expenses, they're each paying their own in their vehicles. I think that's all we need to address here. There's also a request for attorney's fees. I would strongly object to that, and I believe we did that the last hearing and it was tabled. My client doesn't have the ability to pay that. That was already discussed at the last hearing, and that was reserved. My understanding was for a trial or a more robust hearing when we were going to have more information on finances, but not today. And they also asked that she pay for the guardian ad litem in full, which was already dealt with at the last hearing as well. So, and there was a restraining order request as well, which I don't believe is necessary. I think the court can put in provisions in the parenting plan that deal with how the parties are going to communicate. I know they've had no contact and everything has been through attorneys, and Ms. Corey may be recommending something along the lines of an app for limited contact. I think that covers the extent of the issues. So unless I'm missing something, then hopefully we can go forward on that understanding and the property issues are addressed and we can hear from Ms. Corey.
So, Ms. Holder, I'll get back to you in a minute. Let's address the review. Let's go ahead and take care of that matter at this time. And then as to those other issues, I am going to just go through them. I've heard what I need to hear as far as argument from Mr. Roberts. I'll just hear from Ms. Holder to see what other information you may want to add. So Ms. Corey, let's do the review. Where are you as far as your investigation?
I have received intake documents back from both parents. I have interviewed both parents via Zoom. I have not yet been out to do home visits at either residence at this point. I have learned a few things along the way, and that led to what Mr. Roberts mentioned in my recommendation, that the parents use a co-parenting app such as Our Family Wizard for communication. But I do have some other concerns about the way that this, I don't know what to even call it, but the temporary visitation that is set up. I did learn that there is a teenager, one of, I believe, Mr. Pittman's children, who has been doing the actual exchange between with this young child. And I would like for you to address that and see if we can get an adult to be doing that piece of it. But I have concerns about the non-professional supervisors that were assigned in this case. Although there were eventually, I believe there were background checks run on them that were okay. It's my understanding that these are folks who know the father in a pretty short term, and they're not acquainted with the mother in this case. And I guess if I would have had this information, or if I would have been on the case before this was happening, I would have asked that this be professionally supervised visits for a couple of months at least. So to get some professional feedback on the interaction between the father and the young child, is a year old, I believe. Also, if there was some confusion about which party was county pay and which party was private pay at the beginning, and I have not received any payment yet from Mr. Pittman.
So it sounds like the issues that you're having is one, that the supervisors should be professional supervisors, and two, that for the exchange, it should be an adult, as well as the payment, correct? So
yes, and the co-parent, I'd like for them to be using a
co-parenting app. Okay. All right. All right. So with that, council, Mr. Roberts.
So to bring the court up to speed, I'm not sure how familiar you are with the full trajectory here. I came on the case very late after Mr. Pittman through Ms. Holder filed the motion for temporary orders. I was retained a matter of days, don't quote me on that, before the last hearing when Judge Evans made these rulings. My request, Mercedes' request, was for professionally supervised visits. Judge Evans did not do it at that time. So Mercedes is in agreement with Ms. Corey's, I don't want to call it a recommendation today, but if things were on a timeline where we could have gotten this lined up, Mercedes' request has been professionally supervised visits. I haven't talked to her since I heard Ms. Corey's recommendation for professionally supervised visits for the first time this morning. My understanding is Mercedes was always asking for that. I do not know if that is still her position. We can inquire. Mercedes can send me a message if she wants to verify that. That was her request from the beginning. There were background checks. I ran watch reports. I understand, and I don't know these people's history very well, but I've heard that they've lived out of state significantly. I only ran a watch report for Washington. So I do not know the extent of their criminal history. I'm not making any accusations. I'm just representing that the report was not a national wide or anything along those lines, and I don't know their long-term residency. I do agree with Miss Corey. My understanding is they're recent acquaintances, and Mercedes has had some concerns with them as well. There have been other concerns about some visits, some miscommunications, and I don't think we need to go into that. I don't plan on raising that, but we can get into that if Ms. Holder wants to raise it. I don't think that's germane to this hearing. With respect to the GA, the payment, if it wasn't clear, my client filed a motion for county pay. Judge Evans granted that. The order was written inversely, so now it should be entered such that my client is county pay, Mr. Pittman is private pay. Also, and there's been a 3-day-a-week schedule. I spoke with Ms. Corey a week or two ago. I don't want to presume or put any words in her mouth. My understanding, that was loosely, and I communicated to her, I wasn't sure if Judge Evans had the 3-day-a-week schedule because he wanted to keep it 3 days a week, or it was kind of a holiday plus some makeup time because there was some confusion about the weeks before about contact. I don't know if Ms. Corey's position is that we should retain that 3-day-a-week schedule. We did talk, and I thought, please correct me if I'm wrong, that 3 days a week was a little accelerated for the current knowledge about the situation. So Mercedes is requesting a 2-day-a-week schedule if that's agreeable with the court. If Ms. Corey would recommend it, she can do a weekend day and a weekday. My client's okay with slightly longer visits as opposed to 3 hours. She's okay with for example, a 5-hour visit on a weekend and a 3 or 4 hour visit during the day, during a weekday, if that works with the schedules. But the 3 days a week is really hard with their work schedule. So I believe that's everything for now, unless there's any other questions or responses I need to provide. Mercedes did just message me and say that supervised visits are fine as long as we have a recommendation the court is okay with, whether it's professional or not. But I would defer to the court on that, and certainly Ms. Corey.
Ms. Holder? And I'll just tell everyone overall, this is why, and I'm not blaming Ms. Corey at all when I say this, this is why I don't like the verbal reports on the day of hearing, because then attorneys can't talk to their clients about what their thoughts are and have the information in front of the court. It's all kind of that morning. And so just to give you an idea, and again, I don't blame Ms. Corey at all for this because this is how it was set up, but just to let you know, that's my concern. But go ahead, Ms. Holder.
I will go through quickly the 4 recommendations for Ms. Corey. As far as the non-professional supervisors that have been involved in this case, the reason that happened the way it did is Ms. Pittman, before she got Mr. Roberts as her attorney, she was not cooperating with me at all for exchanges, and Mr. Pittman had not seen his son in 3 months. And so when we got in front of Judge Evans, we needed to put some kind of order in place so that Mr. Pittman could see his son. And the court was very clear previously with Judge Warning that Ms. Pittman's family could not be trusted, for lack of a better term, to help facilitate those exchanges. So we put those 2 names forward, and the judge signed off on those 2 names. Now, I am fine with changing those supervisors now because there has been some confusion around the visits, and also people's work schedules have changed. So I was going to ask the court to switch those names anyway. But my understanding is that's how we got to the non-professional supervisors in 3-week schedule, and that the 3-day-a-week schedule was not supposed to remain permanent. It was just a way for Mr. Pittman to be able to see his son, as he had been withheld for 3 months at that time. The second thing, as far as visits being professionally supervised, I will leave that up to the court, as it appears here there is some issue between the parties as to their ability to agree for third-party supervisors. However, he cannot afford it. That's one of the reasons we had to ask for attorney's fees, is there's been so much litigation in this case already because of Ms. Pittman's legal maneuvering prior to hiring counsel, which is why we had to ask for such an exorbitant amount of attorney's fees. My client just doesn't have the money to pay for both an attorney due to the highly, just the issues of this case and how complicated it's got. So we have no problem with professional supervisors and supervised visitations. As to how my client is going to afford to pay it, that is the other issue. I would refer to the court on that one. I will talk to my client about having the GAL fees paid. He is here, so I will make sure that he understands that he is to get those done immediately. I do not disagree with the wizarding app. I think that's a good idea. There was some issue regarding communication over the past week with the weather and with Martin Luther King Jr. Day. There was some correspondence going on between Mr. Roberts and I that wasn't getting read because it was a holiday weekend. And so there was some confusion. There were some missed visits, which again is why I'm not disagreeing that we need to change up the visitation schedule, potentially the visitors. We just need to make sure that it is in the interest of both parties. Now, as far as confusion regarding visitations going on before Mr. Roberts was retained, again, I would say that there was absolutely no confusion. We basically had to pin down Ms. Pittman to get her to cooperate, and I'm glad that she has Mr. Roberts now, but we are concerned that if we don't get some type of order in place, she's just not going to follow it. As we have submitted before the court, she's literally said, if an order is not in place, I'm not going to do it. And so that is where we stand on that. So I think the biggest issue here is making sure that we can get some supervised visitors. Oh, and the daughters supervising. The daughters did not supervise alone. They were there. They are Jackson's siblings. They were a half-sister, so they were not there facilitating exchanges. The supervisors were also there. It's just the daughter was with Mr. Pittman.
All right, so let me ask this, Ms. Corey, in regard to the visitations, how often do you think at this point?
If I were starting from scratch in this case, I would say twice a week.
Okay, for a couple hours each, or?
Yes.
Okay. All right, so here's anything further, counsel?
I just wanted to clear things. I'm not sure how central this is to the court's analysis, but I did review some communications between my client.
I'm not worried about it.
Okay.
It is, let's start where we're at and get this going where it needs to go.
I had the, go ahead, Your Honor, I'm sorry.
So in regard to the co-parenting app, that will be put into effect. The parents need to use that as a means to communicate between each other, Family Wizard or whatever it is that they can put into place. In regard to the exchange, doesn't sound like that was necessarily a minor that was doing that, but it does need to be an adult. But let me talk about the exchange. The exchange is going to be at a professional supervisor's facility. And at this time, Dad will need to pay for that. It will be 2 hours, 2 times a week. And again, similar to what's been said, I think from what I saw, Judge Evans was just putting something in place to get something going and moving forward. So with that, that's what's going to happen in regard to the supervision pending the guardian item's final report. And then if there are any issues, obviously you can bring that back. So I think that takes care of that part of it. So in regard to the other temporary orders that were put into place, any further response on that, Ms. Holder, at this point? I reviewed your motion. I reviewed the affidavit.
No, Your Honor, I would still ask for some portion of the attorney's fees at this point, just due to the amount of litigation that we still had to do. I understand that it's been tabled, but I'm still going to ask for it.
Okay. So in regard to the property, it sounds like that's an agreement that the respondent will have the 2004 Ford Expedition. The petitioner will use the Volkswagen. And so that is agreed. In regard to the debts, it sounds like that part of it is agreed, that they will each pay their own rent, lease, and utilities. And that the petitioner will pay the vehicle's payment for the Volkswagen. In regard to the fees and costs, I understand, Ms. Holder, why you are asking for what you're asking, but what I'm hearing is that, at least at this point from the financial part of things, that the petitioner does not have the funds. I understand that she's hired her own attorney, but I'm not ruling on it today. I think it is something that needs more financial information. I understand the basis that you're asking for it, Ms. Fuller, and in the long term, that may be what comes out. But at this point, I'm not going to be ordering a reserve on the fees and costs. In regard to the restraining orders, I don't know if either of you had any, I didn't hear any comments on that.
Your Honor, if I make a small argument about that, I think Your Honor, I think a restraining order here is necessary just because there have been some issues where mothers or Ms. Pittman's mother, we did have to file for a temporary restraining order. There was some harassment. There's still issues going around where, and this is not in the pleadings, where actually this part is in the pleadings, where we believe Ms. Pittman's mother and or friends, family members were going around and harassing Mr. Pittman and just ruining his business's reputation. He's lost a $500,000 job due to it. And on the stand, when I was cross-examining Miss Irene Fess, Mercedes' mother, she admitted that she's made 4 different calls to government agencies to report Mr. Pittman since these divorce proceedings have began. So I think it's necessary that a restraining order is put in place just so the parties understand that they mind their P's and Q's, and we don't need to have that type of behavior going on in this case. And as I previously stated, I think unless there's an order in place, Ms. Pittman is not inclined to follow it.
Mr. Roberts?
My clients had no contact with Mr. Pittman since the last hearing when there was no restraining order in place. So the need for it, based on the last 5 weeks plus of history, answers the question for the court itself. With respect to the arguments Ms. Holder made, she speaks about my client's mother. My client's not responsible for her mother, and her mother's not a party to this case. She says that she believes, without proof, that there was harassment and harming of his business reputation, and her mother made some calls. That doesn't mean that she did the harassment. It means she made some calls. Regardless, that has nothing to do with my client. My client's not been implicated in any of this. It's simply outside the scope of what this case can control, and no issues have happened for, I believe, months now. If an upset family member does something on behalf of the party to the case months ago, it's not good, but it's not the party to the case's issue. The fact he lost a $500,000 job based on their harassment simply is not, it's speculation at best. And there's no reason for a protective order, a restraining order, excuse me. I think if it's in the order that the parties are to communicate about the scheduling and serious issues with respect to the children, with respect to any health issues, et cetera, and limit it to that and that alone, that's going to cover everything we need. And any violation of a court order is going to be a clear violation based on how the court articulates its ruling.
Ms. Holder, anything further?
Yes, normally I would totally agree with Mr. Roberts and arguments, and I would make them myself. However, I think this is a little bit of a special case because Ms. Fest has intertwined herself in the divorce proceedings and in the restraining order proceedings. In fact, when she was in front of Judge Warning for the second restraining order, there was a protective order that was dropped. When she went in front of the court for the restraining order that was eventually dropped, Miss Mercedes was on camera for the hearing, and her mother was directly behind her, directing her about.
He states that he was not served with a hearing notice. There's also proof from the court that you gave the order to. He was served. There's proof of service by Ralph Carrera in Colima Police Department. It's the order to. He was served. There's proof of service by Ralph Carrera in Colima Police Department. Served? He was served. The immediate court hearing. He was served the immediate and the court hearing. Your Honor, I do need to object to, I believe it's Miss Pittman's mother, Ms. Main's mother directing her.
Yeah, Miss Main, whoever's there with you needs to keep quiet. I just want to hear from you.
Okay. Yes, I would. So again, for proof of service, and he was proof that was provided. There was proof of that. Also, in his declaration, stating that his neighbor has giving him information about my whereabouts and when I'm coming to my house, and saying that I moved out of my residence. That's absurd. That's my place. But for somebody to give information back to the other party about me, I just don't think that's necessary, and it makes me feel really uncomfortable.
Behind her, directing her about what to say in the hearing, and I had to object, and Judge Warning had to direct her and her mother to stop that behavior. So again, normally I would completely agree with Mr. Roberts, but I think it's necessary here to put something in place so the parties understand that they are restrained, and part of that is to work to facilitate a good relationship and a good co-parenting relationship, and that is essentially to say to other parties and other family members, hey, this is not your case, you need to stop, and to put some onus on Ms. Pittman to at least try to curtail her mother's behavior and potentially her own behavior.
So I do not have any jurisdiction over the mother, and so to put any restraining orders in effect to control the mother's or the, I guess the petitioner's mother, I don't. And so what I am going to do is I do think that there have been issues and that both parties need to figure out that they need to keep to themselves and do what's in the best interest of the child, not what's the fighting and the infighting or whatever. So in regard to the restraining orders, on the do not disturb, those orders will be made mutual. So I think that's only appropriate at this time. As far as the stay away, again, the order will be made mutual. Except not the school daycare of the child. That part of it, I don't think is appropriate at this point, other than obviously dad has just the supervised visits. So that's the only place that the visits should be occurring. Do not hurt or threaten. I didn't find any basis for that. So that part of it will be denied. So just the, behavior needs to happen and be appropriate. So hopefully both of them can figure that out. So at this point, what I need is Ms. Holder, if you could go ahead and prepare the order, just primarily because you had made the motion for the temporary orders. If you could go ahead and do the orders. And then I'll put a presentation on February 6th. Until those orders are in place, what is currently in place will remain, so that there are still continued visits for dad until those orders are signed. So, but let's get this done. I'll set it on February 6th for presentation if you're not able to get agreed orders to me prior to that time.
Your Honor, with respect to the scheduling, I know we talked about 2 times a week. I assume this is going to be subject to the supervisor's availability, so we're not going to put timing in there. Until the hearing on the 6th, you want 3 times a week visitation or 2?
So I just want the problem is that these people seem to have problems not following unless there's an order. So that's the only reason I'm saying follow the order that's there at the moment until we get these new orders into place. I know it's not ideal, but it's only for 2 weeks.
Okay.
Give me 1 second. My client wants to ask me a question. I want to make sure that we don't need to address it just now. He was just asking the same clarification that Mr. Roberts was asking for.
And I understand. Yes.
I apologize. If that is not in effect until the 6th of February, the final report is actually due March 1st. That isn't going to give me a lot of feedback from the supervisor.
The problem is we don't have court next Tuesday. So I'm just setting it on to the next available specific date.
Okay.
And I understand that. I want them to get the orders and hopefully they can agree and just get me the orders to sign and the orders can go in effect as soon as possible, which is what I want. But the problem is if they don't agree on what the order should say, then it needs to be on a docket so I can rule on it. And the 6th is the next available.
Okay, thank you.
It's an unfortunate set of dates.
If there, this is maybe central to today's hearing, but I think that I'm not going to have an issue. Mercedes is not going to have an issue if Ms. Corey needs more input, if the supervised visits don't really get to the point where she can get a robust bundled input from them. We said on a pretty quick turnaround because it was a pretty emergent and urgent issue. And if there's more time that's needed, I don't think there would be an objection from our side.
Okay. We'll address that if it's requested, but I need to keep going here. Anything further?
No, thank you.
All right. So that leaves the final. That takes care of that matter. The amended temporary parenting plan.
That's correct. So I think the easiest way to go through that is to just look at page 2 of opposing counsel's objections and just kind of go through those one at a time. She kind of lays those out by section.
Since they're my objections, I'd actually like to go through the sections because there's additional language here added. If you look at page 1 of my objection.
Hold on just 1 second.
Yeah.
I need to make sure I initial something that I didn't. Looking at temporary parenting plan 1A. Go ahead, Ms. Winkles.
Yeah, so we've got the first page and under abandonment, it should say obviously neither parent has any of these problems. Under B, obviously, it should be emotional, physical problem and neglect. Those were reserved pending the GAL report, as you stated. We've actually included the transcripts from that here, and we also bought the CD. They're rough transcripts. They've not been transcribed by somebody with skill to do that, but they are there just to assist us here. The issue we have are sections 4, 5, and 12, and I'll go through section 4. There's limitations imposed. Your Honor stated that you didn't have enough information, that you were concerned with mother's mental health, but that you were really wanting you wanted the GAL to be involved. You can't have limitations with having reserved under findings. So you don't get one and not the other. You can't have limitations if you have no findings. The findings are reserved. So we'd ask that any of the limitations under section 4 be stricken. That section should also be reserved. So section 3B should say reserved. Section 4 should say reserved. Under decision making, we should have school and healthcare. Those should be with dad, and everything else under there reserved. Reasons for limitations. Again,
let's go through this bit by bit so I can make changes as necessary. So under paragraph 4, Ms. Baldwin.
So 3B is reserved. Under section 4, the court can put in limits. In this case, the court said it does have serious concerns for the safety of the child, and these are orders that the court made, that she needed to abide by the anti-harassment order and that the child was not to have unsupervised time with the mother's boyfriend who presented a domestic violence risk. The court specifically made that order. So to just say, I'll just strike that off, that's not appropriate. The court made that specific order for the safety of the child. This is an appropriate place to put it because, again, some of the concerns here warrant that, and the level of concern warrants putting it here. Does the court want to stop at just section 4?
Yeah, I do.
And this is better for section 14 in that the court stated, and you'll see again, the transcripts under my objections are there. The court stated they had concerns, but that they had no information. And this was the problem, to impose a limitation without information. It is a safety mechanism in the court, absolutely, to not have this person that hasn't been vetted by the GAL yet, to have, these mental health allegations. The court will remember a lot of these.
Let's not re-argue.
Okay.
Hold on. We don't have time to re-argue. If we are going to do that, I'm going to stop. I'm going to take the other cases. And so I heard argument. I get it. I know what you talk about. And I agree that I don't necessarily say that you can't put limitations on a parent just because you don't make certain findings. But I don't have a problem, honestly, with either place. They are things that are supposed to be done, but I have no problem putting them under paragraph 14. They still apply, and I haven't made any basis, so those can get moved to paragraph 14, and then just put reserved under 4.
Okay.
All right. So I know about the religious upbringing part and the extra curricular activities. Let's address the religious upbringing part in regard to
so the religious upbringing, this is just a constitutional statement, and honestly, Ms. Winkles has an almost identical statement in her section 14. This is immaterial.
Yeah, that one's not the concern. It's the healthcare part that was the concern.
The healthcare part is actually the vast majority of that mirrors the restraining order that is, although the court will have to dig deep into Odyssey. We did attach it to my client's declaration, but there's a huge section that is part of their restraining order that talks about a medical emergency is where a child's airway is observably. So like all of that pieces are there. So a big section of this is part of the restraining order already. So we just copied and pasted a big section of this. The father being authorized to make healthcare appointments is basically already stated because the father is the decision maker. We're essentially allowing and making it clear how the mother is going to be involved. We're including the mother in a reasonable way and kind of detailing how that's going to happen. That's not a bad thing. That's a good thing in a high conflict case, to detail out how specifically that's going to happen. And this was in my proposed order. This is not new. This was in my proposed order.
Ms. Winkles?
Yeah, my concern is this was never litigated in that last hearing. It was not talked about or argued by both sides. There is a current restraining order, which is in place for this very reason. We don't need that language copied. And the word majority of concerns me because it means it wasn't just copied word for word. We have additional words in here that weren't included in the restraining order. If the restraining order is in place, why does this need to be in this order at all, especially when it wasn't litigated? That order still controls. That order is still in place. Nobody's changed that order. Additionally, that order is between my client and wife or fiance. I can't remember Mr. Klopp. It's not between Mr. Klopp and my client. It's not between child and my client. The only one restrained is the wife, girlfriend of Mr. Klopp, or the protected, I should say. It doesn't make sense to put it back in here when it wasn't argued and it wasn't ordered.
So unfortunately, that's not true. A bunch of the other children that are my client's children are also protected parties. So those children are in the household, they're in the cars. And we also don't want situations where, that restraining order fell off and now it's sort of a free for all.
So in regard to these paragraphs, understanding in looking at the conflict that was going on between these parties and determining what's in the best interest of the children or child in regard to the healthcare part of it, the last place we want is for that conflict to be an issue. And so I am going to leave this in.
So moving to 8 then in that case, which was just essentially when it applies. Yeah. The weekends should be defined by the Fridays in the month, not the first Friday. Just the amount of Fridays. I think it's just a word. It should be defined by Fridays in the month, not the first Friday of the month, if that makes sense.
And I adamantly disagree because the first Friday of the month is how you count. So if it's the first, third, and alternating fifth, then the first Friday is how you then count. So mom doesn't get to decide which one is the first. This is the first Friday, and that's how you count the Fridays. So I guess it is a distinction, but it has a difference. And so it's just how you look at the calendaring.
So in regard to this, I've always gone off the first Friday of the month. It's defined by the first Friday of the month. So it will remain as I can't even find the language. Oh, here we are.
Yeah.
I see it. That will remain.
Okay.
All right. Holiday schedule.
Well, under that same section, if there's no school, transfer time should be the same time school lets out. We have it much later than even the Sunday transfer. If there's not going to be school, it should be 3 p.m. if no school, because that's the time mom was originally getting them. Why is it suddenly later if there's no school?
And that's to accommodate work schedules, because if mom's picking up directly from school, my client doesn't need to transport anywhere. But if it's a non-school day, then we need to have a transporter. And so sometimes that means somebody has to be out.
And then that limits my client's time who's stay at home while she's working from home, and Mr. Klopp is off on Fridays.
All right, where are you looking? I'm not.
Line's about 8, 9.
Yeah.
So she's looking at, there's a paren right at the end. It says every first, and then there's a paren or 6 p.m. if no school. So it's just what time if no school.
And neither party works on Friday. So it makes sense to have the 3 p.m. trade-off rather than waiting hours, because she would normally get the children at school at the end of school.
Okay. All right. In regard to that, actually what I tend to do is actually go in the morning, but if neither of them working, it can be 3 p.m.
Okay, very good.
Under section 12, oh wait, the holiday schedule, my apologies, section 10. If you look at that schedule, it's overly biased towards the parent with the majority of visitation. You'll see the even odd years are not followed. Typically, these parents have exchanged the split spring break in half. It should still be that way. We also have 4th of July. My client doesn't want that, but what my client does want is to see the child on Christmas Day. My client would like to have Thanksgiving, since she used to be 50-50, and now we've restrained her so much back. These are coming up quickly, especially spring break. I'm not as concerned with Thanksgiving or Christmas at this point, but spring break is coming up, and it makes sense that they split in half of the exchange at 12 on Wednesday.
I maintained them from the last order. So the complaint is I want to rewrite them, but I'm looking back at the March 2023 order, and these are what they were.
And that's when they both had 50-50.
Right. So I don't think that's reasonable to say, well, now I want to rewrite this. I didn't argue this at the time.
So this is a temporary order. It's going to remain as written here.
Easter is not in this order at all, though. Is that something we can take care of rather than come back on at least Easter?
I'll take no position. Your client's call or your honor's call.
Easter, well, Easter tends to go with spring break.
It does, and it does this year.
So if it's not a part of the spring break, I have no problem adding it, and you can do an amended or something to get it to me so it fits in. But yeah, do you know which it is, at the beginning or the end of spring break?
I think it's at the end of spring break this year.
Okay, so it would go to mom.
Okay.
Okay, that'll stand.
Okay.
Okay, anything else?
Section 12, the transportation should just say park and ride. None of the other was argued. Again, we're putting an order from a restraining order, which is in place and still current. It's not going to fall off between now and the end of trial. It's a good order, and it can be renewed quite easily. It just needs to say park and ride. That's what the court ordered. That's what's in the transcripts. Transportation's at the park and ride.
So so 2 things. The restraining order is set to expire in 2024. We do want these provisions to remain. 2, the restraining order protects specifically my client's children as well as his significant other. But we don't want the game to be played that if it's just him in the car, then all the rules are off and we can play this game. So again, we should have sort of the same rules, whether it's just my client in the car or him and the kids or him and his spouse. the rules should be the same. It should be incorporated into this order. That's reasonable.
And Your Honor, they attempted to get that protection order and it was denied. So to then essentially have it without argument now put into this order seems manifestly unfair. They attempted to get dad protected, and now they're going to get him protected without the benefit of having a hearing when it was denied in court previously. That seems really unfair.
Didn't I rule park and ride?
That's what you ruled. It's on the transcripts.
Okay, then it just needs to be park and ride. So you're going to have to get me a new order because I'm not going to.
Sure. Okay. Section 14H, it says the telephone privileges are from age 10. I've never seen an order limit a year. It usually says telephone privileges for the child. It doesn't give an age. What this does is this child's 6. It means that there's no telephone privileges with mom for 4 years. It seems an arbitrary number that was chosen. It's not in the original. We would just ask that telephone privileges are from now. He can call mom can call child. It makes sense that way rather than suddenly picking some arbitrary number out of the air. It wasn't argued.
This wasn't argued and it wasn't ordered and it wasn't discussed. This is a high conflict case. What we don't want is then mothers calling child 10 times a day, fathers calling child in mother's household. The idea is at 10, a child is able to sort of manage some of those communications on his own. At 6, he's not able to. They're basically all have to be facilitated by a parent. I'm
going to stop this. I have other cases I need to get to. So at this point, what I'm going to do is reserve on this because I'd like input from the guardian ad litem.
Okay. So I would just ask,
I'm going to leave it at this for the moment. And then I want input from the guardian ad litem.
Can we also reserve on 14J in that case? That was just separate parent teacher conferences. Can we just reserve for the GAL? I doubt there's any coming up at this point anyway.
It's a little odd. The court can't force my client to do a joint parent-teacher conference.
No, I don't think I can. I think they have that right, and that's up to the school to set them up. Right. And I think the school would want with these two parents to have separate conferences anyhow.
I agree.
All right. So give me a new order.
Okay. Very good.
All right. Thank you, Your Honor.
All right. Thank you.
Yes, Your Honor. Ellie Cotto on behalf of Corey Hoffman. This is my motion to compel.
Cornette Ignacio on behalf of my client, Caitlin Hoffman.
Okay, so I emailed both of you yesterday because this is on twice. One is for temporary orders, but I didn't see temporary orders in there.
I think it was a misnomer on the docket or the docket notice. This is just on for the motion to compel.
Okay. Okay.
I believe that's correct, Your Honor.
All right. All right, counsel, go ahead.
Thank you, Your Honor. So this is my motion to compel. There has been no response from Ms. Hoffman's attorney. I would be objecting to them doing an oral response at this time. They had sufficient time to do some type of response. I think my pleadings are pretty clear. Had to do 3 CF 26 I's to, I've tried everything to get this information. I've done 3 26 I's. I've done a detailed letter explaining everything that I'm missing. I have made phone calls. I've delayed in doing this, and we can't delay any further. I really need to get these documents because they're pertinent to the case. And when I went through and looked at everything yesterday and preparing for this, everything I'm asking for is necessary for our case. And what's happening is we actually answered our discovery. We answered it in its entirety, even though we could have hidden behind some of the same things saying, oh, well, you already have the documents. It's already been filed. In discovery, you're supposed to give that information, and that wasn't done. There's so much missing. And if the court had a chance to receive the letter, it's a lot of documents, a lot of information, and I'm getting nowhere. And we have a trial date coming up the week of the 11th of March. I'm not sure we're going to be ready just because I don't think that we can get the documents together and filed in time. One of the things we are asking for is I'm asking for a date certain that all full documentation be provided by January 31st, that this matter be reviewed on the 5th to make sure that all the documents were provided, that if the full documents are provided, I'm asking that Ms. Hoffman's pleadings be stricken. I can't go forward on this without the documentation. My questions were not vague. I kept it to very relevant and pertinent information necessary to the defense. I'm also asking for $2,000 in fees. If you look at the pleadings I provided and all of what I went through to try and get information, that is appropriate under the rule. So I'm asking the court today to order the docs, all of the answers and all the documentations completed by the 31st. Ms. Hoffman has had since September 22nd to answer these pleadings, and that if it's not provided by that date, strike her pleadings and allow me to go forward. I'm also asking for the court to order fees. I'm also objecting to counsel providing anything orally. He's had time to respond and nothing has been filed, nothing has been provided. Thank you.
Mr. Anagnostou, I would agree in regard to that, but I don't know if you have any other thoughts in regard.
Well, Your Honor, to begin with, this hearing was set up on an order shortening time that specifically indicated that I was to be served January 10th. I wasn't. I was served on the 11th. And so I have been working with my client. My client doesn't live local. She lives in Idaho. I don't disagree with Ms. Kudo's request that this gets set over and that we answer by the 31st. I don't have a problem with that. My client has gotten me supplemental answers, additional information, but there are questions that Ms. Kudo is asking that we have answered, and she doesn't like the answer, and she's still pursuing those questions. So if we have a hearing on February 5th, it needs to be a review of the questions and answers and sufficiency. So a discovery conference, because we've answered. There are some questions that we didn't answer with regards to her medical. We raised a privilege, and Ms. Kudo and I have worked that out, and we have a protective order that we're going to enter, and that information will be released. But so between the ice storm and not being able to get to my office and me being sick for a week, and my client being out of state, it's taken a little more time to get the information. So I don't have any problem providing answers by January 31st and having a review hearing on the 5th. The other requests I object to, there should, I mean, striking my client's proceeding without that. You know, we're talking about a child here. We got a guardian ad litem appointed. She's present, and you know, his best interest in this parenting plan. And so that's an extreme request that's not warranted at this time. So I would agree that this matter gets set over to the 5th, that we could have a review hearing with regards to discovery, but striking my client's pleadings because Ms. Kudo doesn't like my answers is not appropriate. And some of the questions and the answers we've given, she's objected to the answers. That's not appropriate. You know, my client's answers are her answers, but the other information I can get to her by January 31st.
Your Honor. So first of all, he was served on the 10th. My affidavit of service is dated for the 11th, but he was served on the 10th. So he was served according to when we, as soon as we, by the 10th. What he didn't get served was the order itself because it wasn't available till the 11th. As soon as it was available, that was served on him on the 11th. But he got all of the documentation, my motions, my proposed orders, everything on the 10th. Second of all, I've been doing this for a long time. I often get discovery answers I don't like. I don't object to those. This is not an issue of me not liking the answer. It's the issue of I'm not going to answer 3/4 of the question. I'm not going to provide the documents. That's my complaint. They're not providing the documents. They've had months to do this. I can't get anywhere. And that's why I'm asking for a pretty extreme order, because I've never had a case where I've had to do 326 I's, a full letter, numerous phone calls to get what I got, which was ridiculous. It was not complete. If Mr. Anagnostou's client had answered the questions completely and had given me the documentation, we wouldn't be here today. but I keep trying, and now there's another further delay. Wait till the 5th, and then I have to go through this process again. That's going to further delay this. I can't seem to get anywhere, and that's why I brought it before the court. And in fact, I waited to serve my motion, and I called Mr. Anagnosto asking, where's my stuff? I really tried not to do this. I hated to waste the court's time, but there is no other way to get this. So I think that what I'm requesting is fair and appropriate. It is not an issue of not liking the answers. I've provided the court with all of my questions. It's just missing information, refusing to answer, refusing to comply.
I did review the files and record and the including the motion that had been filed. And in looking at this, the trial is set for March 11 of 23, and the discovery was due October 23 of, set for trial March 11, 2024. I think it was just a typo in there. And the discovery due October 23, 2023. When I'm looking at that, there have been 3 26I conferences and still not completed answers. That's a real issue. I'm quite frankly, or honestly, I don't look at this as being something that Mr. Anagnosto has done, but I expect it's a client that, again, just because you're in Idaho doesn't mean you can't provide the documentation that is needed. So you can't just ignore discovery requests, and so the court does find the petitioner in contempt. And that the petitioner can purge the contempt if provides the discovery within 7 days of today's date. Actually, it sounds like you're in agreement that has more time, well, by the 31st. And the court is going to order attorney's fees of $1,500 for the number of hours that it's obvious that have had to be spent on trying to get this discovery, and $150 in civil penalty, and that's to be paid within 90 days for the failure to comply with the discovery at this point. The contempt can be purged by full compliance with the discovery by that 31st. But if there's a failure to do so, and we will review what has occurred or not occurred on February 6th at 9 a.m. So I'm not quite sure about striking pleadings, Ms. Cotto, since you're the client's the respondent.
What I generally do is I ask for striking of her pleadings, and allowing my client to go forward just on his response. Okay. I know that is a little unique. One thing I would ask the court is
hold on. So I wasn't quite sure on that part of it. And I'm not saying that's what will or won't happen. The other option is to strike or not allow any testimony on any information that was not provided. That's another option that I've done as well. So that's another possibility too. And I'll be looking at additional attorney's fees and costs. So again, we'll look further on the February 6th at 9, but that's my ruling as far as today.
Your Honor, just one point of clarification. I didn't file contempt. I just filed for a motion to compel. So
okay. I apologize. Yeah,
so
you're right.
Granting my motion to compel.
Right. The motion to compel.
And then I'll strike the contempt. I may be filing that later in the event that there's no discovery provided, but okay.
All right.
All right. Then we're back on the 5th. I will do the order and get it over.
Ms. Cotto, the 6th, Tuesday.
Oh, the 6th. I'm sorry. Okay. I have nothing further.
All right.
Thank you.
Thank you.